Donald Trump and his defense team filed a highly redacted motion to compel disclosure. Remember, Jack Smith is saying that the government's prosecution team is very small, very narrow. It's just like Jack Smith and a couple friends, that's all. So Trump doesn't need information from all of the other government agencies that are essentially prosecuting him. So Trump says, no. We're going to expand that hula hoop. I want information from Homeland Security, from the White House Counsel, from NARA, the National Archives. I want to know more than just the FBI or just the DOJ. What about the CIA and all of these other entities that were behind this classified document prosecution, because they are the intelligence agencies that govern the classified documents. So they were all involved. They were all colluding to get Trump. And now Trump filed this motion, and we're going to go through this, but we're going to do this a little bit in reverse, because you'll see here, this is the motion from Donald Trump's team. And when we get into this, it is highly redacted. And so we're going to read through the introduction, but as you'll see, look at all this. It's all redacted, okay? Big swaths of this thing that matter are just not, you can't read it, right? You can't read much of it. So we're going to go in reverse. The media wants all of this uncovered, all of this exposed, and so do we, obviously. So we're going to go see what the media, Jack Smith and Trump are fighting about. Then we're going to come back and read that actual motion and unpack what's there and see if we can fill in the gaps. So here is what Jack Smith said. So Trump filed this motion. It's a motion to compel. Jack says, you don't need all of this discovery. You don't need this evidence. You don't need CIA, National Archives. We give you what you need. Trump says, no, Judge Cannon ordered them to give us a bunch more stuff. So Jack Smith responded, and let's take a look at this motion, and we'll fly through these so we can get into the good stuff. But here's what Jack Smith said, all right? He says, look, all right, they filed this motion. They want us to disclose a bunch of stuff to them. And Jack Smith's very unhappy about what Trump filed. He says, 2 days ago, Donald Trump filed a motion to compel, we're going to read, that are replete with mischaracterizations and baseless arguments. Concurrently, Trump also filed a motion for leave to file a redacted brief. So this is a classified documents case. So we've got ex parte filings, which means they're not notifying the other side that they're even filing stuff with the court. We've also got stuff that's being filed under seal. So we have questions about whether the other side knows about it, but we don't know about it because it's all under seal. We've got the judge reviewing things in camera, right? Just behind closed doors and behind closed chambers. So it's a lot of confusion about what's going on here. So they say Trump, he filed another motion, and that was joined for a redacted brief, right? But the government, writes Jack, we support full transparency of the record. Yeah, right. But they say consistent with witness safety, right? With national security. What the heck does that mean? National security. So when they say they support full transparency, they're going to tell you why they don't want full transparency. And they want it to be consistent with the court's protective order, because transparency, if we have transparency, will expose the defendant's distortions of the factual and legal landscape in their motions to compel. But nevertheless, out of the concern for witness safety and the reasons below, so if they say, well, our transparency will show that Trump's lying, but we can't do that. Why? Witness safety. The government opposes the motion, and in effect, the motion to disclose, we oppose that, in effect, which is a motion to disclose for the same reasons, okay? It's going to lead to discrete, sensitive information coming out. And they say, we can't see any of this stuff inside this motion that we're about to read because of harassment and intimidation. And they give us some case law here. The concern apply to this case just like any other. So our safety, right, of our witnesses is a prime concern. Public disclosure of their identities could infect the testimony. And so accordingly, the government objects, right? Jack Smith, who just told us how much he cares about transparency, objects to the unsealing of any of the stuff that we want to see. Why? It's going to reveal personally identifying information. And one document identifies 2 of the signal intelligence subcomponents that are redacted in the superseding indictment. And another identifies the FBI code name of a separate investigation. And one also discusses uncharged conducts, and so we can't talk about them. And so they tell us, right, for the foregoing reasons, court, please deny any request to unseal. Now, Trump says in response, a very quick response, he says, Trump takes really no position about any particular redaction request by counsel. In other words, if Jack has a problem, like with witness safety or national security, this is Trump responding. He says, that's okay. Like, we can deal with that. Okay. But the office, they didn't make any effort to substantiate its vague claims about what actually is their concern about witness safety or national security. So they continue. Like, okay, if there's a witness safety problem, we'll help. If there's a national security problem, we'll redact it, no problem. But many of the, quote, potential references in Trump's motions, many of the things we're talking about, they've already been disclosed in public reports, and so we just like to talk about it. And in some instances, this data came out. Why? Because of leaks from the prosecutors. So Jack Smith released it, not us. And in the FOIA releases that we discussed in the motions, which also reveal some email addresses. Now, they say also that NARA just released some more information. NARA released additional information after this was filed. So they say Jack just wants none of this unsealed. In other words, make Jack explain what should be redacted, okay? He should be the one to justify it. They say the special counsel, Jack Smith, which is not so special, illegally appointed, by the way, because he's not appointed, did not even cite the First Amendment or any common law frameworks at all. Totally inappropriate. He says, nor has the special counsel's office cited any supporting case law or any other materials as well. That's just not the law, noting that there is a notable dissonance between their view of how this works and the law. Now, the special counsel and their office, they chose to bring this case, and they have taken unprecedented steps to fuel biased press coverage and public interest in the proceedings in order to interfere with the election. These steps have included seeking the unsealing of the warrant that was used to raid Mar-a-Lago. They've also gave numerous public statements about their politically motivated prosecutions. They conspicuously and tellingly timed their tellingly defensive public statements by Attorney General Garland. He released a new statement on January 19th, 2024. Garland came out and said that the DOJ's imprimatur behind the office's speedy trial was because of public interest, right? Now, although the office seeks to strike a different tone, it's difficult to understand how this litigation is necessary, that we can't do this in public. Just let us do it in public. Don't let Jack Smith just make generalities. Oh, like my national security, my witness intimidate. Get specific, man. We'll work with you. Otherwise, it should be public. Now, this is the press wanting to jump into this. Now, they're getting excited about, oh my gosh, they say, here's the motion of the press to intervene to unseal all of this. Again, we're going to read that here coming up. So the press jumps in and look at all these people like, oh, this is juicy. It's everyone you can see here. It's basically all of the press. I think they got them all. Washington Post, Telemundo, LA Times, Guardian, USA Today, Fox News, Wall Street, CMG, Dow Jones, all of them are there. And they say, look, our coalition respectfully moves to intervene on this. Hello. We see that there was a motion filed with extensive redactions that we're going to read through, and they're asserting that they're not required to do so, right? So in other words, Trump and the defendants are saying, we made these redactions, but we don't think we need to do those. Now, they say they sought approval to file these in unredacted form because they want this stuff public. But the government, Jack Smith, these losers over there, and deranged thugs, they oppose the unsealing. Now, this court has already reminded the government, so Judge Cannon has already told them, what is your particularized basis for this? What is your specific reason? You don't just get to say, oh, this is not Judge Chutkan's courtroom, okay, where you can just say, our democracy, and she does whatever you want. Here, because the press coalition agrees, all of them, that these are presumptively public, the government, okay, the government must carry a burden to justify the sealing. It now supports, the media supports unsealing this. So the media gives us the background. We know the story. Here is, in large part, a summary of what Trump wants. All of these 11 items of footage or of discovery. It's a lot. So let's jump right into the motion to compel. This is Donald Trump's motion to compel. It's a 68-pager, a lot of redactions in here, so we'll hit the highlights. But this is filed in Judge Cannon's courtroom, West Palm Beach in Florida, United States of America versus Trump and the co-defendants, Donald Trump's motion to compel discovery, saying that Jack Smith is obligated to give him a lot more evidence in this case than he's currently giving him. Here's how Trump's defense starts. Your Honor, Judge Cannon, President Trump respectfully submits this memorandum and the accompanying classified supplement that, of course, we cannot read here, in support of Trump's motion for an order regarding the scope of the prosecution team. So we like to use the hula hoop analogy here. Who's inside this current hula hoop? Well, Jack Smith says it's FBI and DOJ, that's it. Trump says it's everybody else. To compel them to give us information from those other government entities. Saying Jack Smith has disregarded basic discovery obligations and DOJ policies in an effort to weaponize the Biden administration and their egregious efforts bringing this criminal case in pursuit of an objective that Biden cannot achieve on the campaign trail. They're using this to slow down President Trump, who's leading in the 2024 presidential election campaign. Now, the patent absurdity, writes Trump's defense, of the office's efforts is illustrated by the fact that while working towards a historic landslide victory in the Iowa caucuses, President Trump was also preparing, to Your Honor's attention today, the record of misrepresentations and discovery violations that have marred this case from the outset and illustrate that the office, Jack, has disregarded fundamental fairness and its legal obligations in favor of partisan election interference. New evidence, says Trump's team, that was obtained via requests under the Freedom of Information Act reveals that politically motivated operatives in the Biden administration and the National Archives, NARA, formerly led by Deborah Stidel Wall, began this crusade against President Trump in 2021. This is the classified documents case. There are 22 FOIA releases from the DOJ and NARA attached as exhibits here. Nearly all of these exhibits, though heavily redacted based on the FOIA rules that have no application to a criminal case, we can't see anything, represent discovery violations in which Jack Smith failed to produce documents that support arguments and positions that Trump's defense has articulated since at least October of last year. The FOIA requests, coupled with other evidence scattered throughout more than 1.2 million pages of discovery, reflect close participation in the investigation by NARA. So again, the hula hoop, NARA's inside, and Biden administration components like the White House counsel's office were assisting in the government's prosecution. That's discoverable evidence. We also had senior officials at the DOJ and the FBI all colluding. Now, these revelations are disturbing, but not surprising. These are all political, operatives under Joe now. Not surprising at all. The Biden administration leaked to the New York Times in April of 2022 that Biden's view that Trump should be prosecuted. And then guess what happened? In April is when Biden made the declaration. And then in August of 2022, AG Merrick Garland, he took the extraordinary step of Merrick Garland, who reports to Joe, approving the raid at Mar-a-Lago. Garland personally approved it. He's literally in Joe's cabinet. Joe Biden said Trump should be prosecuted. He abided. However, the details reflected in the FOIA releases add force to Trump's long-held position about the scope of Jack's team. And so these materials, they should have already been disclosed by Jack in an unredacted form at the outset of the case, but they didn't do that. They hid all of that from us, and we got it through the back door. We went and got it through FOIA. So this is a violation of discovery rules. Now, the parties' dispute regarding the scope of the prosecution team also extends into the intelligence community and the National Security Council, saying in this regard, the special counsel's office would have the court believe that the prosecutors have only dealt with these agencies at arm's length. Oh no, just like, nothing big. But evidence relating to extensive coordination during the classification review process put the lie to these claims. Now, equally telling, in submissions to you, Judge Cannon, in August and September, Jack's team, they asserted in Trump versus the United States that the intelligence community was closely interconnected with and cannot be readily separated from the investigation. And again, the office's position is disturbing but not surprising. They are commingled and in bed with each other. Now, they said that to you, Judge, and so the prosecutors cannot escape those representations here. They just went back and read what they submitted earlier. Now, these issues are central to the instant motion because Jack Smith is seeking to avert its eyes, looking away from the exculpatory and the discoverable evidence that's already in the hands of other government agencies, like the White House, the DOJ, and the FBI, who provided guidance and assistance as this lawless mission proceeded. And there were other agencies that also supported the flawed investigation, like NARA, the Office of the Director of National Intelligence, and other politically charged components of the IC. As discussed below, even the Department of Energy has taken up the Biden mantle by seeking in June 2023 to terminate Trump's active security clearance, which is a highly inconvenient fact to the office's allegation of unauthorized access under U.S. code. And we learned about that. They said Trump had no active security clearance. He wasn't entitled to have these classified documents. No, this was illegal. But it turns out he actually did have an active security clearance with DOE. So Biden's like, oops, let's terminate that. They amended the agency records to do it. So they say, look, Your Honor, no defendant, not even Trump, is required to predict every single form of exculpatory or discoverable evidence. We can't know what we don't know. It is incumbent upon Jack Smith's office to collect and produce those materials on a fair and judicially enforced definition of who's on the team. However, to be clear, the record discussed below strongly supports the existence of additional evidence of bias and political animus that is central to the defense case and must be produced promptly, Jack. This includes evidence of collusion between the office of Jack and the White House, the DOJ, the FBI, and NARA to use the Presidential Records Act as a law enforcement tool. Rereading it. Go prosecute Trump. They abused grand jury procedures. They violated due process and other constitutional rights, including executive privilege, which Jack Smith didn't even consider, and neither did Judge Beryl Howell, as noted in the dissent in the D.C. Circuit Court of Appeals, when they gave everyone access, Jack Smith in particular, access to Donald Trump's Twitter DMs. Now, the office must produce other evidence of bias. This is Jack's obligation under the rules. Any communications with members, relatives, associates of the Biden administration, communications between members of the Biden administration and Fulton County, that's Big Fanny's office, including meetings meetings with Nathan Wade. All of those are substantiated by legal invoices. So Jack Smith met with Nathan Wade, or somebody did, right? White House counsel, they were flying all over the place. Also, evidence related to analytic bias harbored by the intelligence community is also going to be used as impeachment evidence here. So the essential premise, writes Trump's defense, of the classified supplement that we're not going to be able to see is that neither Trump nor any other party to this action is required to accept the word of the special counsel's office about the alleged sensitivities associated with the documents at issue in this case. The office's own conduct belies these claims. For example, Jack has suggested the documents reflecting the timing and the contents of the presidential daily brief on a given day are among the intelligence community's crown jewels. In fact, there are detailed descriptions of these briefs that were delivered to Trump on the CIA's public website, which are based on the same information, including the directly attributed quotes from the same witness that the office speaks about in hushed tones. Saying additionally, as explained in a separate opposition, prosecutors and witnesses repeatedly ignored the so-called need-to-know requirement, and they shared literal war stories that have no relevance to this case. And so the court should not condone that behavior by permitting the office to invoke the need-to-know requirement to allow them to withhold discoverable information from Trump. Therefore, as discussed, Trump will continue to oppose ex parte proceedings under CIPA that serve as a fraud opportunity for the office to push inaccurate and untested narratives about this case. And we will continue to contest in pretrial motions the meritless claims about these statuses. And so accordingly, for the reasons set forth below, they say the court should conduct fact-finding, so dig into this, and determine what is the scope of the prosecution team. Who else was involved? Now, I want to see this investigation explode and the tentacles go into every stinking crevice of our disgusting government to find out exactly who was involved. But here's some background, just to see kind of how the mechanics work. Here's an early indication of NARA, Deborah Steidel-Wall, we remember her. Almost as soon as Trump left office, boom, they sprung into action. NARA started to work with the White House Office of Records Management, boom. There were exaggerated claims related to record handlings under the Presidential Records Act. On May 5th, less than 5 months after the end of Trump's term, look what happened, a bunch of stuff. NARA's general counsel called Gary Stern, he did something. Stern noted that something, and Stern wrote a draft of something. All of that's redacted. However, in early June 2021, during ongoing good faith efforts by Trump to address the NARA issues, so-and-so did something. In August, there was another email that's redacted. In September, someone else did that. Stern sent an email that stated that this, and we don't know what he's saying. He might be saying, you know, actually there is no prosecution that's possible here. Maybe he's saying the Presidential Records Act is not criminal. Maybe it doesn't authorize a raid, but they did it. In late September 2021, without disclosing that NARA had already drafted a referral letter, White House counsel Jonathan Sue, he did something too. Don't know what that was. And something else happened here. Don't know what that was. Whole paragraphs redacted. On October 5th, 2021, Stern sent another internal email. His email attached a redacted item, which he proposed to do the thing. 3 days later, the Biden administration did the thing. See the exhibits on that. We can't see. Now, on December 30th, one of Trump's PRA representatives, the Presidential Records Act, notified NARA that in response to NARA's request, you can come pick up the boxes. In response to an internal NARA email claiming that some of the materials contained classified markings, then Deputy Archivist Deborah Steidel-Wall did something. I'm sure she referred that over to somebody for prosecution. You know, oh my gosh, classification markings. And she does not like Trump, man, because Trump told her that she had a lot of archives. At one clip, there was a weird clip and she kind of did the old eye roll to him. So in an effort to cover up evidence and biased participation, Jack Smith has falsely claimed that NARA independently referred this matter to the DOJ. Not true. However, the evidence demonstrates that's not true at all. Someone else was involved. According to an FBI report, Stern and Jay Bosanko, also of NARA, what did they do? A bunch of stuff. Here they did this, and they did all this, and they did that, and they did all that redacted stuff. So it sounds like they were colluding. On January 25th, something happened here. Now, on that same day, NARA wrote to Thomas Monheim, the Inspector General of the intelligence community, and he said that we have very high-level potential spillage about the destruction of presidential materials and evidence. Now, the document has not been produced in discovery, but a heavily redacted version has. And so you see here at 3:01 p.m., it sounds like here, on February 9th, on the date that the special counsel's office claimed the referral was made, following events happened. 2:17 p.m., the House Committee on Oversight requested information from NARA. 3:01 p.m., something happened. 3:03 p.m., there was an internal email that indicated that Stern had alerted NARA about something. Then NARA sent a sham referral over to the DOJ, and NARA claimed in the email that Stern had done something. We don't know what it is. Bunch more redactions in order order to avoid that obligation under the Presidential Records Act, which might be a notice requirement, you have to notify someone, but the FBI didn't want to do that. So the FBI then did this to avoid the disclosure notice. However, on February 24th, this happened, and then they said that the 15 boxes that Trump gave them consumed their thoughts. In March 2022, Garland authorized the DOJ and the FBI to open up an investigation into Trump. Now, although NARA and the OIG had been providing the DOJ and the FBI with info to these boxes, the White House counsel's office did not seek President Trump's permission to grant the FBI access to the boxes. In other words, Biden just gave the boxes to the FBI. Now, as Trump and his representatives considered the request, Brat asserted to Trump that in May, they said they needed access to the documents. And so, of course, there's a lot of procedural history here. And here's what the court should do. The court should reject Jack Smith's narrow definition of the prosecution team. He says it's very limited. That's not true. There's extensive coordination and resource sharing. The White House is involved. Senior officials at the DOJ are involved. FBI is involved. Numerous other agencies. And Jack Smith cannot reap the benefits of those coordinated activities without giving us information that could be exculpatory. So therefore, the court must reject their position that their team is so narrow. And the resolution of this issue impacts the rest of the case. We've got to review what they're not giving to us. They say criminal discovery is not a game. This is the law. They have a scope that's defined under Brady. They've got an obligation to give us this material. 11th Circuit has said the thing. A lot of case law here. But here are the teams that actually participated in the investigation. Okay, it's not just Jack Smith and his 3 goons. Molly, the highlighter girl, and Jay Brat from Florida. NARA is a part of the team. NARA is a part of this team because of the agency's participation in significant investigative steps. They collected 15 boxes. They coordinated with the DOJ, the FBI, and the White House. Now, they've already conceded that the OIG was involved in this, especially with that sham email referral. Now, as discussed earlier above, they say, by at least the fall of 2021, NARA's general counsel had said this, redacted. So we know he was involved. One of the first investigative steps that was taken by the FBI appears to have been the blank, probably talking to NARA, went right over to NARA. And so that letter is explaining it's further evidence that NARA must be considered part of the prosecution team. Now, at this time, the evidence of NARA's coordination arises largely from FOIA requests. But what we've got strongly supports that we need access to NARA to see what they got. Now, the prosecution team, says Trump's defense, also includes the intelligence community agencies that participated. The Office of the ODNI, the Defense Department, the NSA, the CIA, the National Geospatial Agency, the NRO, the DOE, and the State Department, all there, saying though the special counsel's office has suppressed these communications that have been spread by all these people, we know through FOIA releases that NARA started to coordinate with the Inspector General of the intelligence community. Moreover, for reasons that were already set forth in our classified supplement, the intelligence community's participation warrants inclusion in the team, and so we need access to know what they know. And the DOJ even acknowledged this. They said that our classification reviews are under the supervision of the Director of National Intelligence, and so we should see what they've got. They also include the White House. Oh, the White House is definitely involved. The prosecution team should include the National Security Council, the Executive Office of the President, the Counsel's Office, and the White House ORM, saying the National Security Council is clearly a part of the team who's been involved in all of this. The council was responsible for the creation and the handling of many documents at issue here, and they're also a part of the team because in September, NARA, the lawyer, sent this over to someone. 2 weeks later, Stern said this, and then in January, something happened here. They've been obsessed with those 15 boxes. And in May, NARA archivist Deborah Wall disclosed that she was acting in part based on communications to the counsel to the president. So NARA is also involved with the White House. So NARA talking to the White House, okay, we got access to NARA, should get access to the White House too. Now, although Biden clearly took steps to create a false appearance of separation, the White House components cannot escape this, and so we must see this material. Similarly, the DOJ, telling us the prosecution team also includes senior DOJ officials at the AG's office, that's Garland, Deputy AG's office, Office of Legal Counsel, and the National Security Division. Following NARA, something happened here, and a lot happened here. It just keeps going and going and going. NARA sent a letter overruling Trump's objection, and just over a week later, this happened over here. And the Attorney General Merrick, he personally approved the search warrant that led to the raid. And at that time, Jay Brat, before all of this was special counseled, he was also working at the DOJ. So on October 3rd, we know this, there was an email on that date, and they were sending this emails, back and forth. Someone else reviewed a Judicial Watch motion, shout out to Judicial Watch, and Brat, who was on the team at the DOJ before he was appointed, or he was brought in as a special counsel, deputy, basically. He was talking to all these people, Olson, Newman, Toscas, several attorneys. And what is this? Bratt told these people, look at this, on August 17th, Bratt, he told Olson, Newman, Toscas, Gonzalez, and several attorneys from the deputy AG's office, he gave them an instruction to, quote, turn off the cameras prior to the raid. What is that? And he agreed, turn off the cameras prior to the raid. On the night of August 17th, Bratt sent a letter to Trump about safety concerns related to alleged video of the raid. Later, Bratt and Gonzalez also coordinated regarding media unsealing requests. And so they're colluding all over the place. Now, the prosecution team is not limited to just Jack's office. It's much bigger. They use the same grand jury in DC for both cases. Assistant Special Counsel John Pelletieri appeared, but dating back to June 2022, something happened here. And Wyndham, he's now a senior assistant special counsel in DC. On the other hand, Bratt participated in other interviews, and collectively these considerations reveal there was no principled basis for limiting scope to the attorneys who are working on the case. It's all of them. They also want the FBI, the Counterintelligence Division. On February 9th, something happened here. We can't see it, but they discussed this in the classified documents. FBI participants included not only personnel from the field office in Washington, but a bunch of other FBI people. This guy, Kohler, he leads the Counterintelligence Division, and at least one agent from, quote, FBI headquarters did this, and so we should see all of them. And what about the Secret Service? Well, Jack Smith worked closely with the Secret Service and his FBI agents at least two important points. First, the Secret Service did all this stuff that we can't see. And second, they did all this stuff that we also can't see. And so all of those agencies should be brought into the discoverable team, and their materials should be discoverable. So they say Jack Smith has an obligation. He's got a duty to go find this stuff from all of those different agencies. Just because it's hard doesn't mean that it's something that you don't have to do. They must be compelled, Your Honor. Trump has made a series of discovery requests, and they're not going to give us the material. And so you need to do it. Here's a lot more case law, and see what else is inside. A lot more redactions, as you can see, and they're just making arguments. They want CCTV video footage. Central to Jack Smith's prosecution is the allegation that they conspired to hide classified documents. But one of the manner and the means of the conspiracy is moving boxes to conceal them. But the concealment allegedly occurred between May and June, which were the days leading up to Trump's attorney's scheduled review of the boxes. Okay, so Trump moved things for the lawyers. As evidence of the fact that Trump attorney 1 did not review all the boxes that contain the markings, they say the storage room was inspected by Jay Bratt. But then the superseding indictment came out, and they said that the documents were not in the room. So therefore, critical to the defense of the special counsel's allegations is about whether these boxes were moved. Who moved the boxes during that time? So put simply, the CCTV footage in this matter is central to Jack Smith's prosecution and our defense. However, Jack Smith's production of the CCTV has been unworkable, and it precludes us from having meaningful access to this discovery. So they're hiding even the CCTV footage. The initial production is 80 terabytes. Here's the correspondence. This is what they've been sending back and forth. Now, each of these folders contains, oh my gosh, I've actually experienced this firsthand. Not, 80 terabytes of data, but the government creates, their proprietary evidence systems. They log the stuff in their systems, and then when they have to give you the files back, you cannot open them. So special counsel indicated that CCTV footage was contained in 21 separate folders as depicted below in their correspondence. So, okay, folders. Now, each of these folders contains hundreds of files that were all compressed using 7-zip, a proprietary software. Decompressing these folders required hundreds of hours. Below is a screenshot of the extraction folder. So there's what one paragraph looks like. Here's another extraction folder. It's probably extracting, going to take 400 years to extract this. Okay, great. Now, of note, Trump's lawyers learned that these files were not produced to Jack Smith in this compressed format. Isn't that curious? Rather, the special counsel compressed them and produced them that would require us to extract them before we could ever review them. Now, their production included proprietary players produced by the camera system vendors. But we extracted the players. We continued to have issues playing the videos. I have literally done this, okay? Like at our law firm, we used to have so many problems with this, and it would be from different prosecutors, right? It was wild. Can't even play it. Well, come into our office and you can play it there. No, we're not going to do that. Defense counsel for Mr. NARA was not able to launch the player at all. Defense counsel entered the below errors and to this date have received no response. So they compress them, they put them into their evidence systems, and they spit them back out, and you can't access it. And then you look like a tech idiot. Now, counsel for Dale Levy area had the same thing. So we consulted tech support from Millstone that actually captures the CCTV footage, and they advised defense counsel that the special counsel counsel's production lacked the required technical configuration files. They reconstitute the evidence and then you can't even access it. So when the lawyers advised special counsel of this, they said to us, well, the FBI also had difficulty viewing the videos and advised that to make the video work, additional files would need to be copied from each of the individual folders, and there are thousands of those that are provided by the special counsel. And thus, from its initial receipt of the video that is crucial to the defense, special counsel was aware of issues that we couldn't even view it. Now, to that end, internal documentation of their receipt and the processing of the CCTV confirmed that the defense was not provided with the video that we can actually use. For example, we sent this and this and this. And so look, Judge, accordingly, just tell them to give us the footage in a manner that we can watch. The government's obligation is to produce this. It defies credulity to suggest that special counsel has satisfied its burden by first altering the raw data that it received and then knowingly producing it in a way that is not even reviewable. We know that Jack Smith has rendered the video viewable because it included key sections of that video in its production of video to the defendants. And so Jack should be required to produce all the video it obtained in a viewable format. And so Trump's defense says, for the foregoing reasons, President Trump respectfully submit that this court, Judge Cannon in Florida, should, following any hearing to resolve these factual disputes, so who's involved? Secret Service, NARA, DOJ, FBI, bigger, broader, and so on, issue an order defining the scope of the Jack team and also compel Jack Smith to disclose the information requested inside and in our accompanying classified document. Signed by Todd Blanche, Christopher Keese, articulating why we need a lot more evidence in this case and why Jack Smith and his deranged thug prosecutors are just covering it all up because it is damning for their case and they don't want to see it. Trump moved boxes around. Oh my gosh. Yeah, so his lawyer could look at it for documents that were declassified that he had every right to have because he was the president. And we have something in the Constitution called the Opinion Clause, which says that Trump, the president, is entitled to the opinions of his officers. They're his. Congress can't turn around and then pass some stupid statute that supersedes the Constitution. Deborah Stidel Wall can't collude to say, you didn't declassify this by filling out our forms. Sorry, your forms don't matter. The Constitution matters. Thanks for playing the game. So this is a motion to compel. I'm very excited about this because this will have some spillover into the rest of the Trump prosecutions. If Jack Smith's team in the classified documents case is expanded, well, we know there's going to be a lot of overlap and they're going to make the same argument in Judge Chutkan's courtroom. And Judge Chutkan is going to issue a different response to this. And we're going to have a little bit of a conflict there between these two sides. And it's going to be just a lot of fun into it. But one of the main claims here was that the Biden administration was colluding on this, something we obviously know. Kamala got asked about this, and she was over on whatever network this was talking about this. And so let's see what she said about this during this conversation.
What is your reaction to those who believe his statements?
Okay, well, let's start with the facts. You just outlined them. So actually, I don't need to repeat them in terms of what have been the allegations about
Spit it out, Kamala.
President. I do believe that the American people care about rule of law and care about speaking truth and acknowledging truth. I do believe in my travels around our country that, for example, a statement that suggests that insurrectionists who attacked our Capitol and committed acts of violence should not be called patriots, as the former president has done.
They'd be called candidates?
Well, the people who attacked on January 6th should not be called patriots. What they did is they attacked our Capitol, they committed acts of violence, and they need to be taken into account and held accountable for those acts. So these are just facts, and we are going to see what happens in terms of any cases that are being litigated in a court of law.
But what about the accusation that it is Biden's DOJ that is overseeing any of the charges against him?
Listen, everyone who is paying close attention understands that there is a clear, non-negotiable division in terms of the separation between our administration and what the Department of Justice does in terms of its investigations, in terms of its prosecutions. And that line has never been crossed.
Does that also intend and include what's going on in Georgia? Obviously, you were a state prosecutor. This is the federal government we're talking about, but there are those who try to conflate what DA Fani Willis is doing in Georgia with the acts of the Department of Justice.
What's the question?
The question is, do you believe that when Donald Trump is making these statements to suggest this is all attributed to the Biden administration or to the Department of Justice, what is your response to people who believe that, in fact, it's all orchestrated as one?
Questions.
What he is saying is not factual, period, and that would not be new for him, would it?
That's a Karine Jean-Pierre line. Kamala, we need a little bit more than that. You're the vice president. You're not Karine.
You look at the rule of law, as you've mentioned, and I do think the American public is very well in tune with discussions surrounding who is above the law and who is not. These phrases come out very easily now. It's almost like the Miranda warnings people are able to recite. When you hear that, juxtapose that to the issue of immunity, possibly. Whether a president should have absolute immunity. Do you think people believe that it's appropriate for a president to have immunity?
I think we're going to have to leave that to the lawyers who are handling the cases.
Some would say it's up to the voters to look at issues of who can be on the ballots as well, in places like Colorado or Maine.
Good
Are
question.
you comfortable leaving that up to the courts or to the voters?
Those cases are all being litigated, and I'll watch as they go through their process.
When you look,
Kamala didn't like a lot of this. Her little one-word answer, one-sentence answer. Who is this woman asking me all these legal questions? This is very complicated. I don't know how to answer this. I thought I was here to talk about Venn diagrams and buses with USB ports on them. So that's what we got from her. Obviously, they're behind it. They are breaking glass in case of emergency. This is the only thing that they've really got. They can't talk about their administration's successes. So the only thing else they can do, take out their political opponent, just like Joe Biden's doing with his other DNC candidates right now, keeping them off the ballots so that he can just skate into victory, because that's how they play. They're cheaters, they're liars, and they're bullies. And we're going to keep covering this, my friends. Donald Trump, in his defense, filed a very nice motion, a motion to compel. Redacted. Media wants to see it. We want to see it, so we can really unpack all of the collusion that was happening between the White House and Jack Smith and Merrick Garland to go after their political opponent. And my friends, we'll be here continuing to cover it. Thank you for subscribing wherever it is you're watching this. If you want to grab any of the PDFs that we just covered, all available at robertgovea.com. The link is down in the description below. Sign up for our newsletter, and don't forget to share the show with a friend or family member. Invite them to come over here and join us so that we see them and you back here on the next one.